So you navigate your life basically answering to two different sovereigns at the exact same time.
Right.
And unless you're really looking closely, you probably rarely notice the seams.
Yeah, that's very true.
Because, I mean, you pay state taxes and federal taxes. You drive on these state highways that are, funded by federal grants.
Right. It's completely blended.
Exactly. You
Yeah.
live under two simultaneous layers of government, which works relatively well until the exact moment those two bosses decide to issue contradictory orders.
And that collision is really the great invisible friction of the American system.
Yeah.
The tension between state autonomy and federal supremacy, it isn't a glitch, it is the fundamental architecture of the country.
Wow.
And when those rules clash, the fallout actually dictates the reality of the market, the environment, and, well, individual rights.
So our mission today for this deep dive is to basically crack open that invisible code, right? To see how that power is actually balanced. And to do this, we are looking at a really fascinating stack of sources. We've got excerpts from an MBE, multi-state bar examination, constitutional law prep masterclass script.
Which is quite a mouthful.
Right. It is. And that's paired with this study philosophy piece called The Jurisprudence of Joy.
I love that title.
Me too. I found that second piece particularly compelling.
Right.
Because it argues against just like blindly memorizing these doctrines.
Right, because that's what everyone tries to do.
Exactly. It challenges us to see this dense, high-stakes material as a lens to understand the hidden machinery that decides literally everything from the warning labels on your cereal to the safety gear required at your workplace.
Yeah, knowledge becomes truly valuable when you actually understand the mechanics behind it, not just the rote rules.
Right.
So the legal mechanism resolving these clashes, it's called preemption. And it derives from the Supremacy Clause.
Okay.
But preemption isn't just this free-floating policy tool where a judge simply looks at it and decides which law feels more practical today.
It's not just a vibe check.
Yeah. No, not at all. It is a rigorous, sequential legal hierarchy. It determines precisely when federal law displaces state law.
Okay, so before we can even weigh a state law against a federal law, we have to verify the federal law actually belongs in the ring.
Yes. The absolute first step.
The masterclass script refers to this as the Episode 2 Gold Rule, and it functions as this strict gatekeeper.
Right. Is there a valid federal law in the first place?
Right, because if Congress lacks the enumerated power to pass the legislation, the whole preemption analysis it stops instantly.
Exactly. The foundational premise of our government is that Congress is not a general legislature.
Right.
They only possess specific powers enumerated in the Constitution, right?
Yep.
And they rely heavily on mechanisms like the Interstate Commerce Clause.
Right, so they can't just pass laws about literally anything they want.
No. And the sources use this hypothetical regarding local school discipline to illustrate the limit, which is great.
Oh, yeah, I remember that one.
Right. So suppose Congress passes this sweeping statute dictating exactly how local middle schools must handle detention.
Okay.
And they include this incredibly aggressive clause stating, this federal law overrides all state and local school board rules.
The natural assumption for most of us is that, well, the federal government said it, so they hold the trump card.
Right, but purely local school discipline, assuming it has literally no connection to the national economy or interstate commerce, that falls entirely outside congressional authority.
Wow.
So that federal statute is unconstitutional from the absolute moment it is drafted.
So an invalid federal law preempts absolutely nothing.
Nothing at all. The aggressive wording of that preemption clause is completely irrelevant because the underlying authority it doesn't exist.
That's wild. So the state's educational rules just remain completely intact.
100%.
It's essentially like someone cutting to the front of the line at an exclusive club.
Right.
And they flash this shiny VIP pass.
I love this analogy.
But when the security guard actually inspects it, the pass is just a counterfeit. The text on the laminate might say all access in big bold letters, but without the underlying legitimacy, you aren't getting through the door.
That is exactly it. The
Right.
authority has to be genuine.
Right.
And, we should probably expand the scope of what constitutes a valid federal source, too, because it goes way beyond just statutes passed by Congress.
Oh, right, like agency stuff?
Exactly. Valid agency regulations. So rules, promulgated by the FDA, the EPA, or the FAA, those carry the exact same preemptive weight.
As long as they're within their boundaries, right?
Right, provided the agency is acting within the boundaries of the authority that Congress specifically delegated to them.
And treaties operate with that same supreme authority too, don't they?
They do.
The sources highlight that a valid operative treaty instantly overrides a conflicting state law.
Yes.
So if a state enacts legislation forbidding foreign nationals from owning commercial property within its borders, but then the federal government subsequently enters into a valid treaty guaranteeing reciprocal property rights for citizens of that specific nation, well, that state law is just instantly displaced.
Precisely. Because, foreign policy and international agreements, they require a single, unified national voice.
That makes sense.
The Supremacy Clause ensures that individual states cannot just undermine the diplomatic commitments of the entire country.
Right.
So as long as the federal source, whether that's a statute, a regulation, or a treaty, is constitutionally valid, it establishes the supreme law of the land.
Okay, so assuming the federal law clears that initial hurdle, right? It holds a valid VIP pass. The most direct way to determine if it overrides state law is to just examine the text.
Right, look at the paper.
We look to see if Congress explicitly mapped out the boundaries.
Yeah.
And this is called express preemption.
Yes. Congress physically writes a clause into the statute detailing the displacement of state law.
But wait, if Congress says, like, we are talking over food safety, doesn't that just automatically mean every single state law about food is instantly wiped out?
No, and that is a very common trap.
Really?
Yeah, the mere existence of an express preemption clause doesn't end the inquiry at all. The battleground immediately shifts to the actual scope of that text.
Oh, so the phrasing acts as this highly specific boundary line.
Exactly. A common mistake is assuming that a federal law claiming jurisdiction over an industry automatically vaporizes every state law adjacent to that industry.
Right.
But if Congress explicitly preempts state laws that are, say, different from or in addition to federal rules regarding food labeling, they have drawn a very, very narrow box.
Okay, the food labeling versus torts hypothetical perfectly captures this, I think.
Yes, let's walk through that.
So if a cereal company complies with all the federal labeling requirements, a state legislature cannot suddenly mandate that the company add an additional state-specific neon warning sticker to the box.
Right, they can't do that.
The state statute imposing that new labeling requirement is expressly preempted because it is literally in addition to the federal mandate.
Exactly. But the mechanism of the market isn't just driven by front-end regulations.
Right. Things go wrong.
Right. Let's say a consumer eats that federally compliant cereal, discovers it was contaminated during manufacturing, and they get severely ill.
Ugh, terrible.
Right. So they file a tort claim in state court, suing the company for product liability and negligence.
Okay.
The company's defense attorneys will inevitably point to the federal statute, and they'll argue that federal law expressly preempts state interference in food safety.
Oh, interesting. So does it.
No, the defense would fail.
Really? Why?
Because a state tort claim for product liability is fundamentally different from a state statute dictating a labeling requirement.
Oh, I see.
Congress preempted ex-ante labeling rules,
Wow.
The requirements imposed before a product hits the shelf.
Right.
They did not preempt ex post compensation,
Right.
the right of a consumer to seek damages after being harmed by negligence. The tort claim falls entirely outside the narrow linguistic scope of that express preemption clause, so the state lawsuit survives.
Wow, the precision required there is just fascinating. Narrow preemption means narrow displacement.
Exactly.
But, Congress cannot possibly foresee every single iteration of state interference to draft a perfectly clear express clause every time, right?
No, they definitely can't.
So often, a federal statute is just silent on the issue of preemption, yet the federal government clearly intends to be the sole authority in that specific arena.
Right, and that silence forces the courts to pivot from express preemption to implied preemption.
Okay.
And that begins with field preemption.
Field preemption. Okay, what is that?
This doctrine activates when federal regulation is so pervasive and intricately comprehensive, or the federal interest is just so overwhelmingly dominant, that courts infer Congress intentionally left zero room for the states.
So it's like this invisible keep-out sign. If the field is occupied, it fundamentally changes the nature of the state's relationship to the law, doesn't
It
it?
completely changes it.
Because even if a state passes a statute that perfectly mirrors the federal law, like a law specifically designed to assist the federal government, it gets thrown out.
Yep.
The state is penalized simply for trespassing in an occupied zone.
Exactly. The Supreme Court identifies uniquely federal interests where this applies, with immigration and nuclear energy being prime examples.
Okay, that makes sense.
The rationale is really grounded in the sheer complexity and the national importance of those systems.
Right.
The federal government maintains this massive, delicately balanced framework for visa categories, entry requirements, deportation protocols.
They're huge.
If an individual state decides to create its own supplemental penalties for immigration violations, it disrupts that entire national framework.
It's kind of similar to moving into an intricately designed, fully furnished apartment.
Okay, I like where this is going.
You might own this beautiful new couch that perfectly matches the aesthetic of the living room. It might objectively enhance the space,
Right.
but it just doesn't matter. The apartment is fully furnished. There's physically no room for your addition. The field is occupied, so you have to leave your contribution outside.
That's a great way to think about it. The structural integrity of the federal design relies on that absolute exclusivity,
Right.
because a patchwork of 50 different state-level immigration penalties would render a cohesive foreign policy totally impossible.
Yeah, that would be a nightmare.
However, the sources do note an important exception regarding partial regulation.
Oh, really?
Yeah. If the federal regulatory scheme explicitly leaves gaps, then, using your analogy, the apartment isn't fully furnished.
Oh, okay. So like workplace safety regulations often operate this way, right?
Exactly.
A federal agency might extensively regulate specific industrial hazards, but intentionally leave other niche hazards totally unaddressed.
Right, allowing states the freedom to step in and fill those specific empty corners with their own protections.
So the field must be genuinely and completely occupied to lock the states out entirely.
100%.
Okay, so we've examined scenarios where Congress explicitly claims a territory and where their pervasive presence implies total ownership.
Right.
But it seems like the most complex friction occurs when both the state and the federal government possess a legitimate right to operate in the exact same space. The field is not fully occupied, and yet their rules inevitably grind against each other.
And that brings us to conflict preemption,
Okay.
which divides into two distinct analytical tracks: impossibility and obstacle.
Let's start with impossibility.
Impossibility is the easier mechanical test. It applies when it is physically and mathematically impossible to comply with both directives simultaneously.
Right, the commercial truck hypothetical demonstrates this perfectly.
Walk us through it.
So federal law requires interstate commercial trucks to display a highly specific standardized safety label right on the side of the trailer.
Okay.
Meanwhile, a particular state passes this strict highway beautification law prohibiting literally any labels or text on commercial trucks other than the company's registered name.
Right. So a driver cannot physically affix the mandatory federal sticker while simultaneously obeying the state mandate to keep the truck blank.
Exactly.
Federal law demands an action. State law forbids that exact action.
Right.
Because dual compliance is mechanically impossible, the Supremacy Clause dictates that the state law is preempted.
Okay, so that mechanical friction is super straightforward. But the second track obstacle, preemption, that's where the real danger lies for legal practitioners and policymakers, isn't it?
Oh, absolutely.
The jurisprudence of Joy Pease points out that this is where our natural intuition leads us totally astray.
It really does.
The trap is assuming that as long as you can manage to obey both laws without breaking either one, then no conflict exists.
Right, but the capability of dual compliance does not shield the state law from preemption.
Wait, if I can follow the state rule and the federal rule at the exact same time without breaking either, how can there possibly be a conflict?
To understand obstacle preemption, we really have to evaluate the ultimate architectural goal of the federal legislation.
Why?
Was Congress attempting to build a ceiling, or were they attempting to build a floor?
Okay. If we look at the auto emissions standard hypothetical, we see the mechanics of a ceiling, right?
Exactly.
Congress enacts a federal law creating a uniform national standard for vehicle emissions. The underlying economic purpose there is uniformity.
Right.
They want automotive engineers to design a single exhaust system that can be legally sold across the entire national market, rather than forcing manufacturers to navigate this chaotic, fragmented web of 50 different state regulations.
Exactly. But then a state, motivated by genuine environmental concerns, enacts a law imposing a significantly stricter emission standard than the federal baseline.
Okay.
Now, mechanically, dual compliance is completely possible. A manufacturer simply designs their cars to meet the rigorous state standard. By exceeding the federal baseline, they automatically comply with the looser federal rule. Nobody is breaking either law.
Yet the state law is still thrown out.
Yep.
Because by physically complying with the stricter state standard, the manufacturer destroys the entire purpose of the federal statute.
Exactly.
Congress prioritized a uniform national market. The state's stricter rule shatters that uniformity, acting as an obstacle to the accomplishment of the federal objective.
You nailed it. The state law frustrates the purpose of the federal scheme. Congress built a ceiling, right? They established the absolute maximum burden that could be placed on interstate commerce regarding those emissions.
Right.
When the state tries to build higher, they become an obstacle, regardless of whether a company can physically comply.
The contrast becomes really clear when we examine a scenario where the federal government builds a floor instead of a ceiling.
Yes, let's look at the floor.
So suppose a federal statute establishes a minimum safety standard for the manufacturing of children's toys. The legislative intent isn't absolute market uniformity here. The intent is to guarantee a minimum baseline of protection, basically to prevent a race to the bottom among manufacturers.
Right. So if a state legislature reviews that federal baseline and decides, it just isn't protective enough, they might impose a stricter safety standard for toys sold within their jurisdiction.
Right.
And again, dual compliance is mechanically possible by just manufacturing to the stricter state standard.
But the outcome of the preemption analysis completely flips here.
It does, because the state law complements rather than frustrates the federal objective. Congress established a protective floor. The state is essentially just adding more structural support to that floor.
Right.
The stricter state rule aligns perfectly with the federal goal of maximizing child safety. There is no obstacle to the federal purpose, so the state law comfortably survives.
Recognizing whether a federal framework is designed as a rigid ceiling to protect a market or a supportive floor to protect a population, that fundamentally alters how you view the friction between the laws.
It totally does. It requires analyzing the intent and consequence of the legislation, not just the blind mechanical application of the rules.
Okay, so up to this point in the analysis, the federal government appears essentially unstoppable.
It kind of does, yeah.
Between express text, occupied fields, and the incredibly broad reach of obstacle preemption, the sheer gravity of federal supremacy just seems to pull everything into its orbit.
Right.
Do the states ever receive the benefit of the doubt when these rules collide?
They do. The architecture of federalism demands a counterbalance, and the courts provide it through a doctrine known as the presumption against preemption.
Oh, nice.
The judiciary does not casually erase state sovereignty, particularly when the legislation involves areas that have historically belonged to the states.
Right. The sources outline these traditional police powers, like health, safety, family law, property rights, ordinary torts, and local land use.
Yes.
These are the historical domains where state and local governments have regulated daily life long before the massive federal regulatory state even expanded.
Exactly. When a preemption case involves one of these traditional areas, courts apply a strong presumption that Congress did not intend to supersede state historic powers.
Okay.
It acts as basically an evidentiary thumb on the scale in favor of the state.
But the Masterclass script is careful to define the limits of that presumption. It operates as a tiebreaker in ambiguous cases, right? It is not an impenetrable shield.
Correct.
Because if Congress drafts a statute with unmistakably clear intent to preempt state family law regarding, say, the distribution of a specific federal pension, the federal law still wins.
Always. The presumption merely forces Congress to be incredibly explicit when they invade traditional state turf.
Got it. And the necessity of that clear intent leads us to one final critical misconception regarding the balance of power. The sources call it the overlap alone trap.
Yes, this is a huge one.
The intuitive leap many people make is assuming that the moment a federal law and a state law regulate the exact same conduct in the exact same arena, one of them inherently must be displaced.
Right. The assumption is that two sovereigns cannot occupy the exact same square of the chessboard.
Exactly.
But we can test that logic with the workplace discrimination hypothetical.
So let's do that.
Both federal law and a specific state law explicitly prohibit age discrimination in the workplace.
Yep.
They govern the identical subject matter, regulating the exact same behavior of the exact same employers.
Right. So if we run that scenario through our established hierarchy, the reality of dual sovereignty emerges.
Walk us through it.
We check for an express clause declaring the federal government the sole arbiter of discrimination claims. There isn't one.
Nope.
We check for field preemption. Has the federal government regulated employment law so pervasively that states are structurally locked out? No, employment law is heavily shared.
Right.
So we look for conflict. Impossibility. Well, it is remarkably easy to comply with both laws simultaneously by simply choosing not to discriminate.
Exactly.
Obstacle. The state law doesn't frustrate the federal purpose. It amplifies the exact same goal of protecting workers.
You've got it. Because there is no express displacement, no completely occupied field, and no mechanical or purposeful conflict, the two laws peacefully coexist.
Wow.
The overlap alone is not enough to trigger preemption.
So an individual can potentially face liability under both the state statute and the federal statute simultaneously.
Yes.
The federal sovereign and the state sovereign are issuing the exact same mandate, and you are fully accountable to both.
The system is perfectly designed to tolerate that overlap, provided the state isn't undermining the federal framework.
That structural tolerance completely reorients how you view the laws governing your daily life.
It really should, yeah.
So, just to synthesize the framework we've extracted from these sources today, when state and federal rules inevitably collide, we navigate the friction through a sequential hierarchy.
Right.
We start with the gold rule. Confirming the federal statute, regulation, or treaty is actually constitutionally valid.
Step.
From there, we check for express preemption in the text. If it's silent, we look for field preemption to see if the federal presence is so pervasive the state is locked out.
Yep.
And finally, we analyze conflict preemption, checking for the mechanical impossibility of dual compliance, or that more subtle trap of obstacle preemption, where a state law frustrates the purpose of a federal ceiling.
That is a perfect summary. The framework provides a rigorous logic to the chaos of dual sovereignty.
Yeah?
But, the jurisprudence of joy philosophy invites us to look forward beyond the established hypos.
Oh, interesting.
We establish that the presumption against preemption protects states in areas where they possess a long traditional history of regulation, right? Like local land use or family law.
Right, the historical turf.
Exactly. But the friction of the next decade will not occur on historical turf.
Oh, wow.
We are rapidly moving into entirely unprecedented regulatory environments. We are facing the realities of commercial space mining, the deployment of autonomous artificial general intelligence, and the commercialization of direct-to-brain neural interfaces.
Oh my gosh, and there is literally zero traditional state history in any of those arenas.
Exactly. If a state, say, California or Texas, moves aggressively to pass an AI safety statute, and the federal government subsequently attempts to establish a national regulatory ceiling to protect the global competitiveness of American tech firms, well, the collision is inevitable.
Yeah, it's going to happen.
But because there is no 200-year history of states regulating neural interfaces or orbital mining, the courts may determine the states are simply not entitled to the presumption against preemption.
Wow. The tiebreaker just vanishes when the history doesn't exist.
It vanishes.
That fundamentally shifts the balance of power as technology accelerates.
The Supremacy Clause is about to be stress-tested in technological frontiers the framers couldn't possibly have imagined.
That is a profound lens through which to view the upcoming wave of tech legislation. I highly encourage you to watch the headlines over the next few years as these new state and federal frameworks inevitably grind against each other. Because as we've uncovered today, navigating life under two bosses is completely seamless when they agree. But when they clash, the invisible architecture of preemption is the only mechanism keeping the entire system from fracturing.